Hello, everyone. Welcome to Maitri's webinar, Lawyering for Domestic Violence Survivors. My name is Zakia Afrin. I'm an advocate for domestic violence survivors at Maitri. Many of you may know about Maitri. We have been in the San Francisco Bay Area since 1991, providing culturally responsive and trauma-informed services for survivors within the South Asian communities and others. Together with providing helpline, legal advocacy, housing assistance, and economic empowerment-focused services, we organize events throughout the year to discuss and shed light on issues relevant to intervention and prevention of domestic violence. Our webinar today is a collaborative effort with Sikh Family Center and Family Violence Appellate Project. Before introducing our panel members, I would like to pause and take a moment to remember the recent victims of domestic violence homicides in the Bay Area, as well as other communities. From Sania Khan in Georgia to Karina Castro in San Carlos. We have lost too many survivors this year, just like any other year before. The repeated incidents of senseless violence breaks our hearts, and at the same time strengthens our determination to continue to work towards safety for all our survivors. We are here for you. Our webinar today is designed to begin a conversation on how lawyers and survivors can communicate better and work towards a common goal, asserting survivors' rights in the courts, including safety. Without further delay, let me introduce our panelists. Shabana Ansari is the legal program coordinator at Maitri. After a successful career as a human rights attorney in India, Shabana joined Maitri in 2014 and has been an integral part of our advocacy team since. Arati Vasan is the senior managing attorney at Family Violence Appellate Project, where she represents survivors in complex appeals and oversees the technical assistance program for attorneys and advocates. Protima Pandey, an expert attorney in DV litigation, trainer, educator, and currently an advisory board member at Family Violence Appellate Project. Our moderator is Mallika Kaur, educator, author, lawyer, and co-founder of Sikh Family Center. Mallika, let's begin.
Thank you so much, Zakia. Always a pleasure to be in this amazing company. So my name is Mallika Kaur. I am currently the executive director of the Sikh Family Center, and it's wonderful to be in a space with a lot of other amazing community advocates and attorneys who are advancing the safety of domestic violence survivors in our community. And then in our audience, we have several different groups of categories of audience members. We definitely have victims and survivors of violence. We have those who assist victims and survivors of violence, whether as community members or as advocates and service providers in different agencies, and we have attorneys. So we're going to be talking to different but very interrelated audiences today. And as Zakia said, the theme today, lawyering for domestic violence survivors. What are some of the prevailing questions, maybe confusions, and then what are some best practices we can take away? That theme we feel is really important. It's something a lot of us have been discussing for such a long time, that when we are not in the heat of a particular case or not faced with, this happened and who did this and who did that, like we're not in that tension of one case when things are already going in a way that is not helpful to the attorney, the survivor, the advocate. How can we step back, look at the bigger picture and say, what are our obligations to, dare I say, each other, right? It's definitely attorneys' legal duties, but as clients, what should we know? What should we come in prepared for? What should we expect and what should we not expect, perhaps? And similarly for advocates. We are today want to put this out there, though it seems pretty obvious. We're providing legal information. We're providing what are the rules, what does the law say, what should be happening based on our experiential, this panel's amazing experience. What should lawyers keep in mind? What should their clients and advocates keep in mind? But we're not talking about any specific cases we're not providing any specific case-specific legal advice. So we've read all of your questions and have been going to try to incorporate them, and the panelists are, and I am in my questions, but we also have just about an hour. So as we get into this, also keep in mind, so legal information, we're providing general legal information that applies across the board. We're also recognizing deep power imbalances, right? Attorneys come with a certain amount of power into a relationship, no matter how client-centered and trauma-centered they're attempting to be. How can we try to address that power dynamic instead of ignore it and then later have microaggressions and macroaggressions over that power dynamic, which is very natural given that the information asymmetry, different amounts of information, different amounts of expertise, all of that exists in these relationships. And also we'll say here, for a lot of us, even though we are attorneys by training and of different areas, perhaps of practice experience, whether it's appellate or trial, international or very local or national, all of us recognize that the law is but one part of the support survivors need. It is one part, often not a perfect part, of a survivor's healing journey. So we do want to enter this with that humility. We're not here to say, if you do 1, 2, 3, 4, 5, your attorney will be able to do 6, 7, 8, 9, 10, and then we're done. We do not have any such illusions. We have worked for too many decades on these cases to provide any such simplistic ideas. So with that, without standing between you and the expert panel here, let's start with the needs, the challenges, the confusions. What are we hearing from the ground? So I'll turn to Shabana. Shabana does so much client-facing work and the direct kind of firefighting response work of hearing what are clients saying? What are their legal needs when people call you? What are some themes that you're hearing, Shabana?
Good afternoon, everyone, and thank you for joining in today. Thank you, Malika. I'm grateful for the opportunity to speak on behalf of the survivors today. Today, I would like to share some perspectives that we often hear from survivors. The words legal, law, police, courts, etc. are very intimidating words, especially to immigrant survivors. As many of them are immigrants, they're already facing additional barriers in a foreign land and often get overwhelmed with the process and the law. An important aspect is that the laws of the land are very different from their home countries, where systems works very differently. Survivors who are reaching out to domestic violence agencies have different experiences of the laws compared to the United States laws. I can give an example of India. When a person calls the police, the expectation is that the police will give a warning to an abuser's spouse, his family, and the abuse will stop for the time being. Another example is in divorce cases. Both parties must sign in order to finalize. Default divorce with the no-fault state is a very new information for the survivors. Another example is child custody. In many cases, the mother is the primary caretaker or given complete custody. This is the new information for our survivor to grasp, along with trying to protect themselves and their children, along with all the trauma, cultural shock, and abuse. And having this expectation to seek help while facing abuse is overwhelming to our survivors. It takes a lot of courage for a survivor to involve the police or legal system to seek help. When a survivor reaches out to a domestic violence agency for help, the primary distinction we help them is to understand the role of a domestic violence advocate and the role of an attorney or a lawyer. We connect them with available legal agencies, offer in-house consultation with attorneys for getting advice on their issues, and many times facilitate the communication between attorney and client. I would now like to share some questions that we often hear from survivors when they work with attorneys. How can I hire an attorney? I have no money. How am I going to pay an attorney? My attorney does not understand why I need help. What can I do? I want to be safe and protected, and I want to explain that to my attorney, but I am not able to. My attorney promised me that they will get me an order, but things haven't moved in 1 year or so.
My attorney does not respond to my emails or messages, and I do not know what to do. I have a question, but I'm afraid to ask an attorney because of the ongoing invoicing. Can I connect with my attorney for emotional support? Attorney is asking me to do a non-cleared order. What shall I do? I feel my attorney does not believe that I'm telling the truth. Can my attorney work as a mediator and send him a warning letter? Why am I billed for 2 minutes phone call and a 1-line email? As you can understand, there are 3 issues that mostly come up with clients who are working with attorneys. Disagreement about what should happen in court, understanding the charges, and lack of communication. Many times, the power imbalance makes it very difficult for clients to speak up for themselves or how they feel. On behalf of our survivor, we are very interested to hear how my co-panelists feel about these issues and any recommendation they might have. Thank you.
Thank you, Shabana, for summarizing so much there so efficiently. Yes, a lot of that sounds familiar, and we heard from the client side what is coming up very often. Now let's maybe turn to Arati for the attorney side, because domestic violence cases, as obviously difficult they are for the person in the situation that they're trying to get away from or resolve in some way, are also very, in a different way, but are also very heavy for attorneys. They can be triggering for attorneys. When 1 in 4 women across this country, across cultures, has experienced family violence, domestic violence cases can actually touch way too close to home for many folks in the legal community, whether they ever tell anyone that or not. So it might be close to home because it sounds like a case that they've had that was very difficult, or it could be their personal life that's brought up by a case. But what do you, Arati, think are some of the needs and challenges from the attorney's perspective, attorneys in such cases?
Thank you, and thank you for having me. It's really an honor to be on this panel. Again, my name is Arati. I work for Family Violence Appellate Project, and just to clarify, I no longer run our technical assistance program, but I do run our training and law clerk program. So don't want my colleague who runs the technical assistance program to hear otherwise. So if we're focusing on just sort of what attorneys say as opposed to what mistakes might be being made. And I want to caution, I'm not speaking for all attorneys. I'm also not saying that every attorney feels this way, or even the attorneys I work feel this way. But I think that there are some universal messages that come out, and you particularly see this in trainings and discussions with private bar attorneys, meaning attorneys who are not in the legal aid system. Unrealistic expectations. Right? Clients don't understand the limitations of this system. They expect too much from the court, and they expect too much from the attorney. They don't understand the limits of those roles, right? That's one message. Another is essentially, you want the time and you want to be able to discuss and you want to talk, but you also don't want to pay, right? And I will say, this is sort of an aside, but there are a lot of things that are very problematic about the standard billing system that the legal profession has, which currently, in most cases, is the billable hour, right? So you do get things like, you round up for a 1-minute email, or and I know a lot of attorneys who cut out a lot of things, who subsidize their clients, who stop billing their clients, that type of thing. But in general, if you actually follow the general system of billable hour, all of these things have a cost. Every minute has a cost. You want to use all the legal options in the beginning, like discovery, meaning, getting documents from all sorts of places and finding out things, including like international assets, things like that, but then don't want to pay for it afterwards, right? Or expect it to sort of happen automatically. Another thing is decision making, right? And that can work a couple of different ways. One is assuming the attorney is going to make all the decisions, right? And then not wanting to make decisions, or assuming that they make all the decisions and the attorney doesn't make any decisions, right? So it can be both ways, and it's also how you discuss decisions, right? Like, when do you ask someone, when do you ask a client what they need, and when does a client ask an attorney what they need, and what's what's going on at that moment? Is it in a moment of crisis? Is it in a moment where something has to be done immediately? You know, are you getting a call as an attorney on Saturday at the police station where you're supposed to be doing the child custody exchange, or are you getting the call on, you know, Wednesday at noon and it's about something that's happening next week, right? Communication issues that I would say relate to trauma, but really related to like trauma-related processing issues. So the need to repeat things, the need to say things in multiple different ways, not being clear that the client understands, and not knowing that the client isn't understanding, and not hearing from the client that they're not understanding, kind of, which is a little bit of a catch-22. Sort of this oversharing, undersharing, right? Like a client wants to share way too much and share things that aren't considered relevant or necessary, or that the attorney cannot do anything about, and then they don't know what to do with that information. Or the client leaves out really key, important things that happen that would affect their case. There's a certain amount of, you know, not following instructions, right? A lot of attorneys will say, if so-and-so texts you, do not respond. Or, you know, if so-and-so calls you, do not answer, or do not speak to so-and-so about this. And then clients will do it anyway, right? For a lot of very understandable reasons. This is not a blame fest or anything like that, but it is something attorneys talk about. Another issue is sort of clients not protecting the confidentiality of the attorney-client relationship, right? You know, saying, well, I know you told me this, but I talked to so-and-so and they told me this, right? And once you start talking to somebody else, you're actually jeopardizing the confidentiality of your relationship with the attorney. Sort of, and then the stamina and endurance for the process based on what they want. And this kind of goes back to unrealistic expectations, right? Like somebody mentioned, you know, first of all, an attorney should never be promising an order. That's a big, huge thing. But promising an order and then it's taking a year, those are not inconsistent, right? And it's not inconsistent to say, we're going to get an order and it's still going to take a year. And that's just a thing that, you know, as attorneys we accept, but it's incredibly difficult if you're a client to think about that, and it's not something the attorney can necessarily do anything about, right? But they're the only one the client is talking to about it.
So helpful. And you've already signposted for us where we're going to go in terms of some clarification, some best practices, how to even prevent reaching situations where, you know, people are either talking at cross purposes or super frustrated that one or the other is just not listening, not making decisions, etc. Pratima, could you add and specifically focus on what assumptions clients make about domestic violence attorneys? And I know we are talking in a, you know, culturally, we have cultural commonalities on this panel, and it strikes me even as we're doing that there's also so many differences. So even if, I think if you could address both, if a client has an attorney, if the client's they see has a Desi attorney, but if the client's Desi and has a non-Desi attorney. So I'm going to add that little wrinkle as well, if you could address that, because I know you've seen the whole gamut in your career so far.
Thank you. And first of all, thank you to Maitri for inviting me. Always an honor to do this work alongside advocates who have worked tirelessly, not just in the Bay Area, but across. I do want to begin by addressing something that Malika brought up towards the end, the cultural piece. You may have noticed that we all share commonalities when it comes to culture, at least on this panel. And there's a deliberate reason we decided to come in front of all of you in this manner. And that's because we are overwhelmingly trying to demonstrate that
this too requires assistance. Our community is not immune from what is happening in the world of advocacy for gender-based violence survivors and protecting survivors. Some assumptions that clients make. Why is it important for us to have this part also discussed on a panel where we're talking about lawyering on behalf of survivors? It's important because our approach as advocates and attorneys to clients also needs to be centered in remembering what our clients think we can do versus what we can actually do. Shabana mentioned a few things in her introduction about the questions that clients have. When I train lawyers on representing diverse communities, one of the things that I talk about is the culture of 911. It's something that people don't think of, but it's very common in our lives in this country to pick up the phone and dial 911 when we're in trouble. But if you haven't grown up in this country and that's not part of your fabric, you don't automatically know that you should be calling 911. When a client is walking into the door of a service provider, depending on what hat the client is wearing, whether they're immigrants born here and brought up here, or they speak a language other than English, or they call the police themselves, or were not ready to call the police, and there was some other third-party reason that there was interference, they're walking into our doors as attorneys and advocates with very little information about what we do as attorneys and advocates. And that's the first assumption. The assumption that we as attorneys make, everybody knows about the culture of attorneys. No, that's not true. And when I say culture of attorneys, think about what I'm saying for a second. Not everybody knows what we do. And if they do know what we do, the information our clients have about what we do comes from Hollywood. I blame Hollywood. And go ahead, repeat my words. I do blame Hollywood. And so our clients are walking through our doors and they have this idea of what we can do, and they approach us from that perspective. Now, remember, Arati brought this up as well, and Malika, I know you said it as well, the trauma that the clients are bringing through. And some of the questions that Shabana raised that she hears as an advocate from clients, it's clear that there is that trauma piece as well. So not knowing what lawyers can do and cannot do, the trauma that you've gone through, and all of the burdens that you're carrying to deal with the situation that you didn't cause. Because one of the things that I want everybody to remember is that our client is coming through our doors and getting help from us, not because of something they did, but because something that happened to them. And therein lies the fundamental way in which we have to switch our approach to what our clients are bringing through the door. Our clients are bringing this entire big piece of, I don't know why I'm in your office, something happened to me, please help me. Some of the other assumptions that I commonly have seen clients make, and I've had to demystify, for lack of a better word, is that they're told by whoever it is that sent them to us as lawyers, they're told what we can do. And so what is very important is to begin the conversation by expectation setting, demonstrating first and foremost, if you're an advocate or an attorney, demonstrating what are the limits of your ability to help them. For attorneys, reminding your client about the confidentiality, also letting them know what your hat is, because our clients, I can tell you, they don't have that breadth. Other things that clients, and I've had to unravel this for clients are not usually clear about the criminal process and the civil process. Depending on who asked them to engage with us as advocates or attorneys, their understanding of what we can do for them depends on whether the police said, go get a restraining order, or somebody from the school of the child that the client has said, you need to do something, otherwise there'll be consequences in terms of your custody. So clients are walking through the door assuming that you know what to do for them. step back, expectation set, and then listen to clients. Because the other and the final piece that I'll say in this is that oftentimes when it comes to cultural and non-cultural, it's less about the culture that I come from, that I grew up in, more about the culture of being a lawyer in the court. Oh, I was told that you've done lots of restraining order cases. I have. But that doesn't mean every restraining order case is the same. And so asking the client what it is that you need, what can I do for you? What do you think I can do for you? And clarifying with the client what you can and cannot do. Of course, there's ongoing issues as the relationship develops. And I do see a question in the chat that I will address in terms of closing out a relationship that has gone sour later on in the panel. But I just wanted to share these opening remarks, Malika.
Thank you, Protima, so much. It's always wonderful to hear Protima speak, because her passion brings out, just reminds me of so many things. And culture, such a heavy word, right? It's this word that is used as code in this country for somebody who has an accent, somebody who eats spicy food, somebody who's like this skin color, right? And every police department has a culture. Every DA's office has a culture. Every courtroom has a culture. So what Protima is reminding, especially the attorneys listening, and I misspoke earlier, we don't have only DV attorneys, we have attorneys who may have never done a DV case, and that's why you're here. So welcome. But we as lawyers, right, from the 1L year of law school, are developing a culture too. And the Hollywood piece I second, right? The gladiator-like lawyer who doesn't need any expertise in any particular area and can run in anywhere and do things. That is part of the misinformation in the US culture in general about lawyers. So given all of that, can we just step back and focus on the actual facts rather than, here's a lawyer, they see injustice happening and they can just swoop in and fix everything, that kind of like image, oversimplified image that may proliferate and circulate out there. So Protima, when does an attorney even come into the picture? And and to add to that, when does somebody in your experience need an attorney over having an advocate helping them prepare, helping them get correct legal information? Because advocates do life-saving work every day. You do not have to have a JD to be doing amazing, essential work. And we know that 90 to 95% of people in our restraining order courts show up without attorneys, but a lot of them have advocates supporting. But when should someone have an attorney? When does an attorney need to be in the picture? Can you just demystify a little bit of that too? Thank you.
Sure. And I just say 1 second, we can be gladiators. We're all warriors. Those of us in the audience and those of us on the panel, all of us. It's just not the kind of gladiators that they show in Hollywood, right?
Mm-hmm.
With that, yes, it's very important for us also to recognize that our role as lawyers and advocates, first and foremost, the completely different training. What hat do advocates wear? What hats do lawyers wear? I don't know how to turn off my phone. It's just ignore it. But I do.
We love it. Yeah. So
I do want to say that the key element here is there a pending court action or is there no pending court action? Step 1. 2, does the client want to take court action or does the client want to understand what their options are, right? And 3, in the United States, the criminal justice system is very binary. It doesn't matter what you've heard and read and seen. It is very binary. There's a prosecutor and there's a defender. And so if there's a criminal case, what is it that your client wants in that particular criminal realm? And where does the role of a lawyer occur, if at all, in the criminal realm? Finally, Malika brought up a very important point, and I also heard Shabana say this earlier, and that's where Arati and I connected with the Family Violence Appellate Project. In the perfect world, everybody who needs to go to court or wants to go to court, there's a need and a want, they'll have a lawyer. I'm wearing a little American Bar Association Commission on Domestic and Sexual Violence pin that says a lawyer for every victim. That would be perfect. We're still to get there. But oftentimes the fourth scenario when somebody might need an attorney is if they've gone to court by themselves and several things have happened, but nothing concrete in terms of the protection, safety, or orders that the client needs. So those are the four scenarios. Of course, I'm simplifying it, Malika, and everybody on the attendee list. I am oversimplifying it, but I like the word demystify, because something about our profession as lawyers is very, oh, you're a lawyer. Yes, and I'm also a human being. And yes, and I have empathy. And yes, and, right? And we have to get to that yes, and. I'm a lawyer, yes, and how can I help you?
Thank you. Yes. So when we get questions like, how should I decide on a lawyer? And what then should I expect a good attorney to do? Arati, could you add a little bit there about how should people, like, is it just looking at how much fees is each lawyer demanding, which is obviously a huge factor? What else comes to your mind about how people should select an attorney if they find themselves in that situation of, that search that is so difficult because it's about something that is most intimately tied to every aspect of their lives, but might feel like just another case to an attorney. So there's always that mismatch of their urgency of finding an attorney and what they may be hearing from different offices. So how do they navigate that process and make decisions?
Well, I wish I could say there was a lot that clients could do. But the reality is, especially if it's a situation where there's already an action going on, where you have geographic culture, where you have court culture, where you have attorneys who maybe do this kind of work as a piece of their work and not as their whole work. It's going to be a different experience from attorney to attorney, but it's also going to be a different experience trying to find an attorney. Most people sort of think, okay, well, I'm going to find somebody I know or somebody who knows somebody, right? And unfortunately, as Malika pointed out, there's so many people who have experienced domestic violence, and many of them have had some contact with the legal system and may in fact know legal folks, but it is a relationship. And to me, it's a little bit less about what a client needs to do and a little bit more about what an attorney needs to do to make sure that the relationship is going to be successful. Because let's be honest, attorneys and clients, there may be something in the paperwork that says that clients can walk away anytime, but really in most cases, unless you're fabulously wealthy and have the option to jump around from attorney to attorney or something like that, you as the client, you're really not in the position of power. And as you can see from some of the questions that Shabana brought up, it's like, I'm afraid to ask that question. And this concept of, I'm afraid my attorney's going to drop me, my attorney has threatened to drop me, I think my attorney wants to drop me, that's the reality. Not so much, I have a bad attorney, how do I get a better one? Or how do I pick the best attorney? So in that context, what I hope is that we can get more attorneys who understand how to handle these cases and what they need to know for themselves and how to approach them, so that there's more options, right? There are more options, or that going to an attorney will have a certain level of expectation, so you don't have to worry quite as much about the fact that you have to find an attorney who lives in San Mateo County because your case is there and no one outside of San Mateo County will take your case, right? Because that's the reality, right? It's not, oh, I have all these people to choose from in the state of California, right? Maybe now with virtual things, there's some more options, but generally people are very tied to the ground, so to speak. And there's a lot of sort of local practice culture too, which makes a difference, right? So for sure, I think attorneys need more training and expertise in understanding trauma and the impact on communication, and then making an individual plan for how they're going to work with that particular client. Because of our desire to either minimize the amount of time so we're not overcharging, or to sort of protect ourselves as a profession, we tend to over rely on the written word. And because of that, we think if we put it in writing and tell someone, come ask me if you have any questions, that equals understanding, and it doesn't. And even if you sit down with someone and go through a piece of paper, it isn't necessarily that as well. You need to have reinforcement, you need to have consistency, you need to model behavior that you want to see. Yes, dynamic.
Did Arati freeze for everyone? Okay.
Yes.
Okay. Sure, she's trying to reconnect. Protima, does this bring up any thoughts for you about, yeah, how to set that tone and that relationship, and how to model what attorneys are expecting from clients as well? Or
Yeah, I think, one of the things that I do want to say, it's important for us to find ways to be empathetic, at the same time to remember that our clients are coming to us for our talent as lawyers. It is possible, and if you've attended some trainings that I've done, it is possible to understand and be empathetic about a situation, and yet remind clients that you're there to be able to help them with their legal issues. Arati, welcome back.
Hi, I'm
Finish
sorry
your
about
sentence.
that. I don't know what happened. I think another piece of it is that, a lot of people go into this work with really good intentions, and they want to help. But there's a difference between wanting to help and actually helping, right? And one of the ways in which I think attorneys can get that confused is that they can be sort of like, well, I know better, right? And that works both ways. One, I know the law better, I know the system better, I know the judge better, so you're never going to get this order, you're never going to get that. Your strategy from the get-go needs to be this, because that other stuff, even though it's in the law and you have rights, it's not going to happen, right? So there's that. Then there's the sort of, I experienced this myself and I would have never behaved that way, so why are you behaving that way? Or I'm a parent myself and I don't care how much this happened, I would never do that to my 5-year-old, right? There's a lot of that happens, and I see it all the time, particularly in family law, right? This sort of judgment, right? So there's that judgment, there's the conservatism, there's the sort of not really understanding how trauma impacts communication, and honestly not being really able to embrace change, which is a weird thing when you think about it, right? Because these cases happen over a long period of time and people change during that time. Their safety needs change, their relationships change, their feelings about something that happened in 1 month can change 6 months later. And you may have developed your whole litigation strategy based on them saying, I want to fight for everything, right? And then 6 months later, they're like, you know what, I'm tired. Or you know what, maybe they're not so bad, or something like that. And you, as an attorney, you're thinking, what? I just did all of this stuff and you made me do all these things, but that's okay. That's okay, right? We have to be okay with that. We can't be so wedded to our strategy and our point of view about how a case should go that we lose sight of the person who actually decides how the case goes is the client.
Yeah.
And I guess one other point I would make, and I know I don't mean to take up too much time, but when we talk about decision making, one thing to think about when you think about domestic violence is how many times someone in the context of domestic violence is told either that their choice doesn't matter, they won't be believed, or they're not smart enough or wise enough or experienced enough to make a choice.
Yeah.
Right? You don't know this culture, you don't know English, you don't know this profession, you don't know the courts here, all this kind of stuff, right? And then they come to you, and as an attorney, you're like, well, what do you want? What do you want? and they don't tell you what you want, and you say, well, you have to tell me what you want. I can't do anything unless you tell me what you want. Well, this is not a person in a lot of cases who's been in any way given that freedom, right? And the expectation that they're going to be able to say and articulate what they want and know what that means and do that from the get-go, and then you're going to be able to design your whole process from there, is incredibly unrealistic and unfair to the survivor. I think one thing, one of my favorite things is when I'm with a client and the first couple of times I'm with them and something happens, they're like, well, what would you do? What would you do? Can you tell me what you would do? You decide. And then 6 months later, they're like, no, I don't agree with you. No, I don't want to do that. Right? Because that means that they've taken the value of their own voice and it's been elevated. And that is something an attorney doesn't do for someone, but attorney can help create a space for that.
Yeah, all excellent points. That's amazing. The mismatch between intention and impact is just so important to keep in mind. And we're not here in the jobs of saving people. So jumping into that savior, like, I know what to do and I'll do this, is not helpful, is not trauma-centered, is not client-centered, and has more to do with our stuff, our unresolved stuff as attorneys than the client. So again, we can be gladiators on that theme. I'll continue gladiators who need to resolve their own stuff on their own time and not client time, right? This is why we need to support each other as attorneys. We need to deal with our own trauma. We're not Hollywood lawyers, right? We actually carry this stuff home and it affects us. If the client has that 5-year-old and we have a 5-year-old, it's hard to see that we won't draw some parallels, but we need to do that on our own time, resolve that, and then return to the client to meet them where they're actually at. All right, on this, we have a lot of questions. I'm going to direct this first one to Protima. There's some different versions of this that have been asked. If the abuser has been violating the restraining order and it is not being enforced, what should an advocate tell a survivor? And let's maybe answer this both when the person has an attorney and when the person does not have an attorney, because we hear this often, and we're hearing versions of this question here as well. So violations of restraining orders, what should a survivor with an attorney do? What should a survivor without an attorney do?
Thank you. And, I would say before I answer that question, for everybody in the audience that is working with survivors or plans to work with survivors, start to practice what you're going to say when the survivor says, what would you do if you were in my shoes? Because that is a question. I see Shabana shaking her head. I see all of you answering it. That's a question that comes to us all the time. So when you do have someone who says the abuser has been violating the restraining order and it's not being enforced, it's important to continue to make a record, first and foremost, whether the client has an attorney or not. As an advocate, you must continue to inform your client that they have the ability to file for violation. And it's important to make a record because that's what is used when this has to continue to be escalated. Of course, if you're the attorney of record, then you have civil procedure rules that you can use in order to go to court to get some action specifically on whatever is being violated, and or one thing that I will say, and or check with if the abuser has an attorney, definitely also finding ways to communicate there. I do want to say there is a very big issue that I know when I was routinely representing survivors in court, the restraining orders, when they're entered, whether they're temporary or final orders, do not properly sometimes get recorded and don't show up in the CLET system, the California Law Enforcement Telecommunications System. Yes, I'm one of those nerds that knows that acronym, but I will tell you that as an attorney or an advocate, you must try to find whether it is in the system or not by contacting your local county courts. That is critical because sometimes when law enforcement does show up, which they do sometimes when there is a violation, they're looking at that system. Finally, remember that the reason you're being asked to make a record is so that eventually you can get all those police reports in order to be able to take any further action that you need. There is no point in going back to get another restraining order. That's not going to get filed because procedurally there's one in existence already. But eventually there are ways for you to file for a renewal, etc., or go to Family Violence Appellate Project or do some other escalation in the courthouse for which you will need these records. Yeah, sorry.
And I think you mentioned CLETS, Pratima, so whether you or Arati want to take the question that's come up both from advocates and attorney survivors, CLETS versus non-CLETS.
Oh, okay. I'm going to stop myself from getting on the soapbox. So if you hear soapbox answer, Malika, stop me, or Zakia, cut off my mic. But I will say there is no such thing as a non-CLETS order. Procedurally, legally, I will say this, and I continue to say this. When you file for a restraining order in court in the state of California under California Family Code, that is governed by the California Law Enforcement Telecommunications System, the CLETS system. If you have that action should result in a restraining order or the denial of one, or you withdraw the case, period. Why? It comes back to the first question we started with, enforcement. Enforcement of a non-CLETS order is non-existent. How do you enforce an order that is not in the system for either the courthouse or the law enforcement that's responding? Which is why I will repeat myself, there is no such thing as a non-CLETS order, and I'll stop right there. Arati, clean this up.
Well, first,
Pratima,
it's
Shabana,
sorry,
okay, there
I
are
just want
and
to add
Shabana.
that. Sorry, I just want to add that the non-CLETS order, they also use the word peaceful conduct order. So the client get confused because they often do not use the non-CLETS order anymore sometime, but then use it. It's still a restraining order, but through a peaceful conduct, when client get very confused because they feel it's a restraining order. So that's something that I still feel that, you know, we should address because we have audience who are hearing these words often.
I will remain on mute. Arti, clean this up.
Yes, I mean, that is always a problem. You hear these things, no ham, no harass, annoy, molest. You hear no contact, peaceful contact, those kinds of things. So those are all, for lack of a better word, nice ways of dressing up something that really doesn't mean a whole lot. But I will say this. It is true that there's no such thing as a non-CLETS order in that way. But I think one thing that we have to talk about, and we don't talk about it enough, is why someone wants a restraining order. What do they think the restraining order is going to do for them that is not already happening? We know that restraining orders can reduce abuse. It can change the type of abuse that happens, maybe in some cases make it less physical, that kind of thing. We know a lot of times it transfers to other things. It doesn't completely stop everything most of the time, but it stops a lot, right? But if it's not being enforced and it's not deterring the other person from doing anything, what is it actually doing, right? Yes, there's a finding out there of domestic violence, but there's ways to get that finding without necessarily getting a restraining order, right? So why someone's getting a restraining order and what they think it's going to do for them is not a question we ask enough. There's a lot of like, go do this. The police told me to do this. My friend told me to do this. The advocate told me to do this. The, so-and-so said that this is the way this problem has to be handled, right? And it's not always the way that it has to be handled, right? There are many reasons why having an agreement that doesn't go into the CLETS system that could be used to help mediate behavior between two people may be something that's an option. But that has to be very specific to the facts of the situation. It is not a substitute for a restraining order. It is not at all. It is not at all, right? We have to keep in mind that just like this culture of 911, not everybody wants the consequences of what happens when a restraining order is violated to happen to the person that they have restrained, right? And so they don't call 911. They're concerned about the other person's immigration status. They're concerned about the other person's job. They're concerned about the other person's housing, or they've been led to believe that those things are going to be negatively affected if they pursue a restraining order. So correct information is very important. But it's not that we have to throw everything out, right? It's about choices and understanding the scope of choices. If you have a restraining order, the other person violates it, you never call the police, you never tell the court, you never tell your lawyer. You know, yes, it could be helpful if that person wants to buy a gun, or, you know, there could be other ways in which the system might help with that person. But in terms of your own protection as a survivor, what is it doing for you? Why did you get it? Why do you have it? Right? And that's where I think some things get lost, especially when we're talking about violations, because if you don't have a lawyer and you have violations, a lot of times you sort of think, okay, I just call the police and they're going to know what to do. They don't. A lot of times they don't. There's a mandatory arrest portion for violations of restraining order, but who decides what a violation of a restraining order is depends on who you call, who you talk to, and what their perspective is, right? And that's true in court as well, right? You go to court and you say all these things happen. Yeah, I have this text message, right? And a judge says to you, you know, that's kind of situational. You know, that's a one-time thing. No, you know, and they minimize what happened, even though it's against the law, right? So when you get this sort of setup where you have this order, you think it's supposed to make the other person stop, you do everything that you're supposed to do and nothing changes, right? It's very difficult to sort of look at violations and really understand what is this restraining order doing for you, right? Because a lot of the violations also tend to come up in these situations involving children, right? They're not supposed to talk to the child about anything about this, or they're supposed to pick up the kid curbside, but they're trying to come into the house, right? And that's a violation of the stay away order, all those sorts of things, right? And they get treated as very minimal, or your attorney will say, you know what, don't talk about that. If you talk about that, you know, this is another huge thing I will say, and then I'll stop. Attorneys routinely tell survivors, don't talk about certain things, right? Don't talk about the abuse because it'll just get more complicated. Don't talk about that violation because that's really a small thing and you don't want the judge to get mad at you and then decide that it needs to go the other way, right? And that's something as attorneys we also have to be very clear and careful about, right? That we don't let our own fear, our own conservatism, our own you know, experience with a bench or with a courtroom to limit our zealous advocacy, right? And also be realistic about what happens when there is a violation. What is it exactly does someone want? Did they want to score a point that someone violated it so that they can prove later on that this person is not a good person? Do they want the person arrested? Do they actually want the communication to stop? You know, what is it?
So let's come back to this point about what is it that people want from the legal system. And Shabana started us off with this, and I'm going to return to you, Shabana. What are some best practices you, from your vantage point as a legal advocate working with so many survivors every week, every month? What are some best practices you wish and suggest attorneys should adopt?
I mean, I would certainly start with that attorneys should actually connect with domestic violence organization and spend some time, because domestic violence survivors need different kind of approach dealing with their cases. Like, I would really say that there are different cases than the normal cases, whatever people call it. Understanding about the culture that we come from, as I mentioned in my in the beginning of my talk, that the legal culture is very different. So like there is a lot of expectations. Give them some time to understand, open your door to understand the culture they come from in terms of the legal system. Maintaining a professional relationship is also very important, because I can only talk from here, like I know we are South Asian, but I can talk from the Indian law perspective, because often the lawyers works very differently. So like, that mindset is there. So changing that mindset and just, gently telling them, because the trauma is so ingrained that it takes time. They will keep repeating those information. And that's something that we do as an advocate here, that we told that we educate them and inform them how they will maintain their relationship with an attorney, and what they can come for emotional support to an advocate, right? So those differences are very important, like just giving them a retainer agreement and having survivors to understand the attorney-client relationship is very hard, but I think we have to build up. So I would definitely say, please understand, attend, and involve with nonprofit, especially the domestic violence agencies, attend, get some training, spend some time, like, provide pro bono clinic, or, come and provide pro bono consultations. I've seen that many actually lawyers would want to learn. They are very interested in spending time and understanding how they can provide their services. So I would go back, and the cultural part is very important, because most of the survivors are not fluent. Like, language barrier is a challenge. So like what we say, what attorney understand, that is also very important. So I will go back for those best practices for sure.
Thank you, Shabana. And I will also say we're seeing questions and people sharing experiences that are versions of community members or other people, including in one case, somebody shared here, a judge saying things like, well, you both just need to get along. So there's the culture of the general society towards domestic violence, all society, no matter what color and what immigration background, that survivors are contending with. And especially if survivors think that the legal system is going to be closure and healing, the legal system lets survivors down all the time. So how can an attorney, as attorneys, we need to think, how do we prepare people for this is one piece, how do we connect you to support groups, how do we connect you to therapy, how do we help you build strengths that you have, connections and bonds that you have depended on all your life before this, because victim is no one's full identity, right? That's just one, they were victimized by someone. That's not in itself identity. Pratima, I do want to just turn to you on this dispute question. And I know there's resources for fee disputes that we can highlight, but in general, if attorneys and clients are in a dispute, what do you suggest in like as quickly as possible? But thank you.
I do suggest contacting your local bar association. I myself, for 4 years, served as the chair of the San Mateo County Bar Association Fee Dispute Committee for the local bar. There are also fee dispute panels that you can file your dispute with the state bar. I do want to say that first and foremost, and the most important thing is communication. So if communication has broken down and fee disputes start to bubble up, that's important. I do want to take, because I have the floor, a moment to remind everybody, even if you're an attorney, consider joining the domestic violence 40-hour training. Even though that training is not required by law for attorneys, if you intend to work with survivors, do contact your local DV agency or contact the California Partnership to End Domestic Violence for a list. There are questions about internships. Please look us up. We can give you those resources. And finally, Malika, one thing that I heard Shabana and Arati and you say again and again about culture. Yes, in the perfect world, we would not have certain cultures recognizing gender-based violence and certain cultures not. But I can tell you that no culture is immune to not recognizing gender-based violence. We are fighting this battle for decades now. If you have a client or a series of clients where you're starting to see a pattern of undermining gender-based violence and or no support from the family to get help, feel free to connect with other agencies, domestic violence advocates, attorneys, people who actually will be able to support you in your advocacy for this client. But remember something that was said earlier by Arati, ultimately, we have to power shift and give power and empower our clients until they're ready to make the decision. No matter how much talent and time you have, remember, step back, be available. Remember to tell them your doors are always open if they need help, because they will come. I can tell you they will come, and everybody on this panel can tell you they'll come.
Mm-hmm. We do, I just want to say we do have till 1:15. We've put a survey in the chat. So if you have a chance to respond, we'd really value your feedback as well. So returning to some of the questions, I feel like this one, I'm going to just ask each of you from a personal point of view. It's by one of the attorneys attending, and clearly this is a compassionate, empathetic person who's also enraged at the messages society sends South Asian, Desi women, especially, where, oh, what sort of a mother are you? And, obviously we hear this in other cultures too, but she's talking about seeing it a lot in a cultural group that, both venerates moms and then doesn't stand up perhaps many times to assist moms getting out of very dangerous situations. And for non-moms as well, like, women's roles and lots of ideas about that. What have you found helpful for you personally to do? Again, you're not speaking for what every attorney or every legal advocate to do. When you're faced with a situation where somebody's clearly in danger, they clearly could get legal remedies, but they have been convinced by everyone around them that they've been guilted, really, or maybe gaslighted, we can pick the word, to not actually attempt to seek any of those remedies. So what do you do in, as Protima said, like being there and staying available? How do you negotiate that internal, like, I could actually assist here and you have legal rights and they're being trampled on? What do you do? What do you suggest other well-meaning attorneys in this work to do?
One thing that is always interesting is once people know you do this work and that this is something that you're committed to, a lot of people come out of the woodwork, including family and friends. You become a go-to person. These are not people you're necessarily ever going to represent. These are not even people who are necessarily out of a relationship, but they're people who think, okay, you know something about this. What can you tell me, right? And it's heartbreaking sometimes, especially when it's somebody that, may even be connected by family, or, somebody who, their parents and their kid is acting this way, and the parents all of a sudden become people you don't recognize, right? I think for me, what I've always tried to do, and it takes time, it's not like I had this solution overnight, is to really think about how it's not culture as a label, right? It's not like Indian culture doesn't care about domestic violence, right? That's a mistake. That's just, one, it's not true, but two, it's so reductive, for lack of a better word, right? So you really have to think, I think for me, about the good and the problematic. Understand that there's always going to be both. There's no place you go to and there's no culture you're a part of. I don't care if it's your court culture or your ethnic culture or any of that, where there isn't that kind of problem, that there's things that happen that you're not necessarily proud of or that you're not necessarily sure why it's happening, but you still love. And really, find ways to kind of, not compartmentalize, but understand that, one aspect or one person's point of view or a kind of generalized statement about what something isn't actually the definition of your experience, your culture, and everybody else around you who might share that.
Protima, how do you deal with it personally when there's somebody, for reasons that other than her safety and what is right, is making choices out of influence to not exert her full or fight for her full human rights or be allowed to fight for her full human rights? What do you do?
Yeah, and there's never a perfect client or a perfect lawyer or a perfect judge. I just want to say that up front. And given all of that, I think that it's important to remember that the reminder to your client about all of the things that you can accomplish with them if they choose to continue with the battle. And I call it a battle because it really is uphill, no matter how slam dunk a case you think you have, right? So reminding your client, constantly empowering them with information, right? I attended a webinar on self-care and they used the term hope with facts. Give them hope, give them facts. Hope with facts is very important because then you say, if we continue this path, these are all your choices. And if you make these choices, these are the possible outcomes. Shabana mentioned in her opening remarks about promises made by attorneys. Never make promises. But also if you are seeing, especially if there's a cultural pressure, etc., what has worked for me is all I can share with you. And what has worked for me is to ask people to ask clients to think about whether the people that are pressuring them, and her, it's usually her, right? But I don't want to continue to use just binary pronouns, but think about the people that are pressuring you to not do X, Y, or Z, and whether they will come to your rescue when you need them. Think about in a few years when your children, if there are minor children involved, when they grow up, they are internalizing everything, and our children are very resilient. I will say that, and I will continue to say that no matter how young they are, they're resilient. And they also are internalizing a lot. So also sometimes it's not fair, but I've used children. And I've said, between the two of you, because there are usually two-parent families, so I'm obviously using all of the biases that we have right now of, two-parent family with minor children, but asking your client to think about what will happen if something happens to you. Because often our clients are also in physical danger if they choose not to take actions. And then finally saying that at the end of the day, there is no perfect way to end this. No one's going to walk away saying sorry and we'll be friends and raise children together. At the same time, what is it that you look out and think about your future? What is it that you see as a picture of here's where I want to go? And if that picture involves, it's usually a him. So I will say if your client says, I'd like him to stop XYZ, reminding your client that we can only control our actions and our steps. And thinking about, okay, well, that is fine. Thank you very much for sharing that. I just want us to ask about what it is that you and I can do together. And if all else fails, do what you need to self-care, because rinse and repeat, you have to open your doors the next day and make sure that survivors can walk through your doors, because the courage that it takes to come through the doors, no matter how tough a day we are having as advocates and attorneys, their day is much tougher. And that's what keeps me going every day.
Thank you. The resilience of children is amazing, and the resilience of survivors is another thing I know that keeps us all going in this work as well. The idea of visioning and not having a safety plan that's just like yes, no, or a tiny fill in the blank, instead of what is your vision of safety? And as Arati said before, for different people, it looks different. Why would they even want a restraining order? Would they even want? So that I think is also another thing that I found helpful talking to survivors of like, what is it? What do you envision 3 months, 6 months? What does safety look like for you? And then work backwards to the only way to reach that through a legal means is XYZ. Do we want to go that way or not? And, do it based on that rather than a prescription of here, first restraining order, then we'll file for custody, then we'll do this. So that doesn't land well on a lot of people. Again, if you saw the feedback survey, there's an option to share it's anonymous survey, but there's an option to share your email if you'd like to follow up with any of us. I saw there's a great question of somebody saying, what can especially South Asian law students do to, and I think the earlier question was to lighten the load of DV attorneys and organizations. Yes, come contact any of us. We will would love to tell you more about what law students can do. And Shabana, I would love to give you the final word. Any closing thoughts? I know there are a lot of unanswered case-specific questions, but a lot of other questions really do touch on the power dynamic that we've talked about, and also could be assisted with being more trauma-centered, with being more aware of how many emotions are in play in these cases. So that brings me back to you. You deal with a lot of emotions from people calling and clients, and I'm just wondering if there's some closing thoughts you'd like to share as we all close the session today.
I always feel empowerment is a very big word, right? Huge. It actually brings with a lot of courage and all the resilience that we have been talking about. I always feel that it takes a lot of courage for a survivor to reach out for help, and maybe we are the first contact for them, right? So making sure a good listening, a trust that we are there for help. And going back to what Arati and Protima said, like why it takes so long that for them to decide whether I should take, despite I'm being in danger, what action should I take? But remember, like all their life, somebody else is taking a decision for them, right? So all of a sudden it comes to that, oh, you have to decide because your safety is a paramount consideration here and you have to deal. I feel that as a DV advocate, as a domestic violence advocate or a domestic violence attorney, or if you are an attorney, open your door, provide a space for them to come and talk and share what they are feeling. Give them some time to process the information. It's a lot of information for them to grasp with law, safety, children, education, finances, housing. So there is a lot of dots to connect and it takes time. But they do, like, if they have been in that relationship for that long and they are actually surviving, that's why we call them survivor. I'm sure that they will pass through or go through this, but we have to be there as an advocate, and trust and courage, that's something that we have to provide. Like, there are a lot of other jargons, like, we have to be non-judgmental. We all have that practice, but, we have to show so that they come back. There's sometime they will call once, stop, they will call after 2 months, they will call after 6 months. I think that's a success story for as a DV advocate, that when they are coming back to reach, like, okay, I'm ready to seek help. And I think that's very important for us. Like, we are not closing the door there.
So important, that whole statistic about, how it takes 7 to 11 times for someone to leave. Intellectually, we know it, but in practical reality, whether you're an advocate, a friend, a family member, or an attorney, it is a hard thing. You feel like, oh, all this time sunk. Oh, but it's never wasted time. The person knowing that somebody cares can be the difference between them feeling very desperate and alone and then feeling like they can survive and they can come out and they will again be heard. So never, I'll just close with that. Never think of any of the effort you put in believing and trusting a survivor and affording them respect. Never think of it as wasted time. So sleep well at night if you've done that well, by a survivor and you've actually given them time and space. You've done something that could in fact save somebody's life down the line, or maybe even that day, you'll never know. So on that note, thank you for all those who attended, and this panel is amazing. So it's an honor to be here, and I hope you all have a wonderful, restful weekend coming up sometime soon. I know it's Wednesday, but I'm thinking about that because we all need to rest, replenish, and come back to do more. Thank you. Bye-bye.
Thank you, everyone.
Thank you.
Thanks.